Thank you for joining the Professional Edge. My name is Todd, tax attorney, CPA, and certified financial planner, host here on the Professional Edge for north of 5 years. What we're talking about is what's the plan? Well, we talked about your plan for the income tax planning. Well, let's talk about what your estate plan is. Over half of all individuals don't have any sort of estate plan in force or effect. They haven't looked at it. Well, we all know that we're not getting out of this alive, so we are definitely going to need an estate plan. So, fundamental document that most people know is the last will and testament. Well, that document assigns a decision maker for them to take control of your estate after you pass away and follow your directions, meaning A, collect your assets, pay off your liabilities, and distribute the remaining balance to your named beneficiaries. That's the simple plan, simple process. But the last will and testament is a direct ticket to go to probate. That is it. So if you're trying to avoid probate, then you obviously have to do something different than having a last will and testament. That is a direct ticket. Do not pass go. Go directly to probate type of document. Second thing about a last will and testament is it does not help you one iota if you should become mentally incompetent and still survive. So how is your decision maker going to access your accounts to pay your bills, to pay your property taxes? Let's say if you have a stroke and you're mentally incompetent now, or you are mentally frail. Well, the last will and testament has no controlling interest or any ability to transfer that decision-making authority to your agent. The document in which you need is a durable financial power of attorney. Durable means it survives your mental disability, and power of attorney that deals with all things financial, such as real estate, could be even updating your address with the post office administration and file your taxes. Yeah, you're mentally incompetent. Somebody still has to file your taxes. Well, underneath the financial power of attorney, that agent can file your taxes on your behalf. So that's the second document on what's the plan for your estate plan. The third basic document that all our listeners here on the Professional Edge would need to have is an advanced healthcare directive. That basically says if I am unable to make my own medical decisions, I appoint my agent X to make those decisions. Well, X now could say, let's go ahead and amputate the left finger that became infected, or let's go ahead and do the surgery because the principal was in a very severe auto accident and is in a coma right now. So that circumvents going to probate court and getting a guardianship over the person to be able to authorize any care or treatment for that individual. So the three fundamental documents: last will and testament, durable financial power of attorney, and your advanced health care directive. Everyone listening to the Professional Edge have, or they need to have this at a bare minimum. So in order to start that process, you're welcome to give us a call at 404-250-9798. That number again, 404-250-9798. Now, if your estate plan, you have some real property outside of your domicile state. Let's say you have something down there on the Panhandle in Florida or Alabama. Well, you would be the lucky recipient of ancillary probate. That means probate down in Florida and down here in Georgia. So thinking about that, you got two attorneys talking to each other. They talk slow, they bill heavy. So that's not a good planning opportunity. So what we might want to do is to recommend to you to have a revocable living trust. Some people say it's an inter vivos trust, or grant or retained interest trust. It's called a revocable living trust for simplicity purposes. Now, easiest way to conceptualize what a revocable living trust is a shoebox. You're going to go ahead and establish and build your shoebox, build the trust, sign the document. But if you have the deed that's on the outside of that shoebox, you haven't really accomplished anything. You're still going to go through the probate court process. But think about this. If we retitle that deed and basically we put the deed inside that shoebox, that means you funded the trust, then that condo down in Florida and your residence up here in Georgia is not going to go through the probate court process because the title is already in the name of the trust. The trustee steps in and distributes that condo to the named beneficiary within your trust document. So we avoid the probate court process here in Georgia and down in Florida. So if that is something you want to consider, do give our office a call. So what's another benefit of the living trust? Well, we avoid probate. So the automobiles would be owned by the trust. Think of the automobile title. You retitle it and you put it in the name of the trust. So basically you put that title inside that shoebox. Same thing for bank accounts. We retitle that, put it in the name of the trust. That way we have no probate with regard to our assets. That right there is going to, A, keep your affairs 100% private so your nosy neighbor can't find out what you owned or to whom it's to go to. That's number one. And number two, we avoid the probate court process, which is a long, lengthy process. Think of the horse and buggy and think of an automobile. They're going to get you to the same place, but one is far more efficient than the other. Yes, they're going to accomplish the same goal, get you from point A to point B, but by far and away, the most efficient is a revocable living trust. Now, contrary to what most people believe, most lawyers here in Georgia say, probate's not a big thing in the state of Georgia. Just go ahead and have a last will and testament. And by the way, we'll keep that last will and testament right here in our company files. It's fireproof. And then that way you know it's good for safekeeping. Well, let's think about it. Why do they keep the original will? Because you've got to go see that law firm to get a copy or to get control of that last will and testament, because that is what is required to open the probate estate, the original. Well, that's sort of their seductive way of getting you to come into that office to get the original will so it can be probated, so they can now sell you on the probate services of that law firm and basically get 3% in and 3% out, and that's a 6% charge. Think of a $700,000 estate. 6% is $42,000. That's a lot of money to probate an estate, in my opinion, and especially if you do your planning up front, do your revocable living trust, go from there, do a little bit of work on the front side. It is not anywhere near the cost of $42,000 to probate the estate if you handle everything up front with a revocable living trust. So again, nobody's making it out of here alive, and therefore, why don't you get your estate plan in force, in effect? Don't be one of the people that is the 50% category that have no estate plan in force, in place, in effect. So give our office a call at 404-250-9798. That number again, 404-250-9798. If you want to have a real candid conversation, we can meet up here in Atlanta if you want to test your driving skills, or we can meet in Columbus. Or, you know what, we can hop on a Zoom call and have a brief discussion to see what makes the most sense for you and your family on how to best plan your estate. The other thing is, on estate planning, we got to consider, if you're actually thinking this through, what is the beneficiary of your estate actually going to do? Because a lot of families have individuals that are spendthrifts. I mean, you give them $1, they spend $3. They will leverage up that $1 to owe $2 more. So if you have that spendthrift in the family, or they're in a relationship that's a little rocky and you're not sure that that marriage is going to last, well, let's add to your estate plan that we're going to place the beneficiary's inheritance in a trust. And therefore, if that relationship should go south, then that ex-spouse is not going to be able to attach the beneficiary's trust shares. That right there alone is another thing, because the numbers are increasing from 50% of all first marriages ending in divorce to almost 60% of all first marriages end in divorce. And I think that number is going to continue to decline as people don't commit. They're very fluid. All their information's on their phone. We have this social media and the, one spouse working and the other spouse stay at home. That sort of has left the nest. That doesn't happen anymore. Majority of homes have 2 working members, and the flexibility to just say, I'm throwing in the towel, I'm out of here. So if that's of concern to you, planning your estate, let's establish a revocable living trust. Let's avoid the probate court process. Keep your nosy neighbors out of your business. And then number 2, put those assets in trust for the beneficiary so they creditor-proof those assets. We still allow them to have control, or if they're a spendthrift, then we don't allow them to have control. So if that's of interest to you, again, one of the benefits of being a listener here on the Professional Edge is we have created a very valuable offer to you. It is an inflation buster offer. It is located at emcthebundle.com. That is Echo Mary Charlie, thebundle.com. It gets your estate plan in force in effect. We avoid the probate court process. We do your tax planning. And then number 3, we look at your investment portfolio to make sure you're on track for that safe and secure retirement. So again, take advantage of that. That is EMC, Echo Mary Charlie, thebundle.com. So we have 2 ways to plan your estate. 1 is with a will, and 2 is with a revocable living trust that then establishes an irrevocable testamentary trust for the beneficiaries to creditor-proof those assets to protect them from their potential ex-spouse. Thanks for listening to The Professional Edge. My name's Todd, tax attorney, CPA, and certified financial planner. Make the most of each day.
We've all thought about it. Everyone listening will need one. Not having one can cause untold heartache, family conflict escalating to the point of a lawsuit. One simple thing that avoids all that: an effective estate plan. As a practicing tax attorney, Todd with Estate Management Counselors has completed over 1,000 estate plans during his 15 years of professional practice. He can help you implement an effective estate plan, coordinate your financial accounts, and make sure you have named the proper beneficiaries to maximize your tax savings. Call 877-654-9798 today and let tax attorney Todd help you implement an effective estate plan. Call 877-654-9798 today. As a tax attorney, CPA for over 15 years, Todd has implemented over 1,000 individual estate plans. He has recently authored an especially helpful guide, How to Unlock the Ultimate Estate Plan. This guide has helped many individuals to understand the benefits of an estate plan and how to avoid unintended disasters. has made every attempt to write this in plain English. To receive this valuable guide, How to Unlock the Ultimate Estate Plan, call 1-877-654-9798 and request your complimentary copy today, or by emailing your request to info@emcadvisors.net.